Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. This series covers 4 fundamental questions about property and property law, and today we are talking about the second question, acquiring property interests. So you may have heard about the doctrine of adverse possession, which allows someone to actually acquire title to property when they have treated that property as a true owner would, and when they have satisfied particular elements over a statutory period. At the end of that period, an adverse possessor gets title. But what about people who just use property, like someone who cuts through a driveway to get to their own house? They are just passing over someone else's property, but they aren't acting like a true owner. In certain circumstances, those people have rights too, although through another legal mechanism, and we call that mechanism a prescriptive easement. A prescriptive easement is a right of access which can be granted to another user if for some statutory period that user accesses property of another in a way that is open, adverse, and under a claim of right, but without either authority of law or consent of the owner. So that is a mouthful. What it really means is that a person who has traveled over property repeatedly, openly, adversely, under some claim of right over time, is able to claim that they can use that property permanently. The way that the elements are described are similar to that of adverse possession. And so I would encourage you to watch the video about the elements of adverse possession. However, there are differences, of course, between adverse possession and prescriptive easements. A key difference is what you get at the end. For a prescriptive easement, you get access, usually permanent access. For adverse possession, you get ownership. Once again, permanent ownership, ownership in fee simple. A user who is claiming a permanent easement doesn't necessarily need to claim that the use of property is exclusive. So this is another difference between adverse possession and prescriptive easements. In the driveway example, for example, both the owner of the driveway and the person claiming the prescriptive easement can use it, and the person claiming the prescriptive easement may still have rights to access that driveway permanently. So exclusion and exclusivity does not matter in the case of a prescriptive easement. Also note that sometimes embedded in judicial decisions about prescriptive easements is what we call the lost grant theory. The lost grant meaning referring to an initial permissive use. So there may be a situation where a property owner knew about the use and passively allowed it to continue without formally granting permission. Or it could be that the owner did not assert the right to exclude by bringing a trespass claim. In those kinds of cases, the court will say that the property owner acquiesced to the use. In those situations, some courts will also add that acquiescence means that there may be no prescriptive easement. So it could be that the permission granted actually works against the person who is claiming a prescriptive easement, in that the permission granted might be limited to the person, to a time period, or to the grant as originally stated by the true owner. So keep in mind this theory of the lost grant and initial permission. Also note there's a difference between prescriptive easements and dedications of property to public use. So a property owner might expressly or impliedly grant access rights to members of the public through a dedication. So a dedication might mean that members of the public get a public right of way to property. It might mean that they come to own property, but it's a slightly different legal mechanism than prescriptive easement and the elements that prescriptive easement contains. Usually, a public dedication applies to more people than a prescriptive easement, which might just mean a small group of people or even an individual person, depending on the circumstances. Early in our country's history, prescriptive easements were seen as something to avoid. We will see this in solar rights, which are discussed in another video in this series. But today, most courts recognize prescriptive easements, at least affirmative easements that entitle a person to do something on someone else's property. So I will leave it there, and I would love to hear from you and connect with you on Twitter or through my website where you can sign up to my mailing list. See you next time.